In this ENGtalk, we will be speaking to you about Bill C-27, which contains Canada's proposed new federal privacy legislation for the private sector. Bill C-27 aims to strengthen Canada's data privacy framework. This includes a complete overhaul of the existing private sector law, essentially replacing it with new legislation called the Consumer Privacy Protection Act, or CPPA. Additionally, Bill C-27 introduces the Personal Information and Data Protection Tribunal Act and the Artificial Intelligence and Data Act. Just wanted to note that this presentation contains information in summary form current as of the date of this publication, and it is intended for the general guidance only. The information presented in this presentation should not be construed as legal, privacy, data security, or any other professional advice or service. Before we delve any further into this topic and the implications for professional engineers in Ontario, we'd like to introduce ourselves. My name is Sujoy Chatterjee, and I am a manager within Ernst Young's cybersecurity practice, specializing in privacy and data trust. I am a lawyer called to the Ontario Bar and have advised global corporations as well as local and national government agencies. I have with me Safayat Moahamad, who is also a lawyer called to the Bar of England and Wales, and now serves as a senior consultant with Ernst Young's privacy and data team, working on global privacy and data management issues. So to set the stage for our discussion of Bill C-27, we're going to provide a brief overview of how private sector privacy law has evolved over the past few decades. Canada's existing privacy law, the Personal Information Protection and Electronic Documents Act, or PIPEDA, arose from privacy principles established first by the OECD and later adapted by the Canadian Standards Association. As you can see on the timeline, PIPEDA became law at the turn of the century, so on April 13th, 2000, and it was first applied to federally regulated works such as airlines, banks, and broadcasters. So then that slowly expanded to include any organization that collects personal information in the course of commercial activity. With the passage of the EU General Data Protection Regulation in 2018, this is the GDPR, the precedent was set for stricter, more comprehensive regulations. Larger fines for data breaches, which are now in the hundreds of millions of dollars for large organizations. And as comparison, within Canada, PIPEDA currently limits fines to $100,000 per offense at most. These numbers dwarf the penalty regime we have in Canada. The GDPR has spurred legislative reform around the world, and Canada has responded to this. So in November of 2020, we had the release of Bill C-11, and that was our first introduction to the CPPA and the Personal Information and Data Protection Tribunal Act. The September election, however, in 2021, halted all progress on Bill C-11, causing it to be tabled. And now it's been picked up. So we are, as of June 15th, 2022, we had the announcement from Innovation, Science and Economic Development of a new bill, Bill C-27, which is the topic of our discussion today. And it's called the Digital Charter Implementation Act for 2022. So this is an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. Now, while this legislation still has to go through several parliamentary procedures, we anticipate major changes in Canadian privacy law in the coming years. So now is an ideal time for the professional engineer community to be proactive in future-proofing their privacy posture. Some additional changes on the horizon for the Canadian privacy landscape include the appointment of a new federal privacy commissioner and Ontario's proposed provincial privacy legislation. On June 8th of this year, the Prime Minister's office announced Philippe Dufresne as Canada's latest privacy commissioner. Mr. Dufresne was a senior general counsel at the Canadian Human Rights Commission and is expected to recommend a rights-based approach to the proposed legislation. For practitioners, this means that we are likely going to see language that grounds privacy as a fundamental right for Canadians. In Ontario, there have been renewed calls for a provincial private sector privacy law, as well as updates to the province's existing privacy and access regime. In the Provincial Privacy Commissioner's annual report, released last June as well, there are calls for a Made in Ontario private sector privacy law, enhanced privacy protections to meet the needs of people and business in Ontario, and to fill important gaps in legislation across public, private, and health sectors. So this is a strong signal that Canada is prioritizing privacy, data protection, and individual rights. And it looks to be a trend that's here to stay. In our next section, we will dive deeper into the proposed changes in the CPPA and the updates that are coming to PIPEDA, and how that impacts organizations, how they manage privacy obligations. And in doing so, it's important to realize that the information principles from PIPEDA will remain at the core of any future state of legislation. So on that note, I'm going to pass it over to Safayat, who's going to continue into a further discussion of the CPPA.
Thank you, Sujoy. One of the requirements under CPPA is the establishment of a privacy management program. While many private sector organizations would be familiar with the similar requirements for privacy management under PIPEDA, a requirement for all businesses under the CPPA is that businesses must have policies and procedures addressing how the organization protects personal information, manages privacy complaints, trains employees, and offers an explanation of all privacy-related policies and procedures. Additionally, in developing its privacy management program, the organization must take into account the volume and sensitivity of the personal information under its control. The organization must, on request of the commissioner, provide the commissioner with access to the policies, practices, and procedures that are included in its program. Upon review, the commissioner may provide guidance, recommend corrective measures be taken by the organization in relation to its privacy management program. Furthermore, if an organization transfers personal information to a service provider, the organization must ensure, by contract or otherwise, that the service provider offers an equivalent level of protection to the personal information, which the organization is required to provide. The CPPA has essentially incorporated the GDPR concept of data controller and processor in its accountability section, vis-a-vis data owner and service provider. A similar approach is apparent when identifying purposes. In order to determine if purposes recorded by an organization are appropriate, some of the key consideration would be whether the purposes represent legitimate business needs of the organization and the effectiveness of collection, use, or disclosure in meeting those legitimate business needs. This resembles the GDPR concept of legitimate interest and indicates organizations should have a policy that explains the thresholds of a legitimate interest balancing test that takes into consideration the sensitivity of the personal information, whether there are less intrusive means of achieving that purpose, whether any loss of privacy is proportionate to the benefits, whether a reasonable person would expect the collection or use for such an activity, and that the personal information is not collected or used to influence anyone's behaviors or decisions. Based on such analysis, if an organization determines that personal information it has collected is to be used or disclosed for a new purpose, the organization must record the new purpose before using or disclosing that information and consider whether consent is required. On the same principle of consent, the CPPA allows for the use of de-identified data for internal R&D and socially beneficial purposes without the consent of the individual. However, an organization must not use de-identified information alone or in combination with other information to identify an individual, barring some exceptions, of course, such as to conduct testing of the effectiveness of security safeguards, conduct testing of the fairness and accuracy of models, processes, and systems, or to conduct testing of the effectiveness of its de-identification processes altogether. Under CPPA, de-identification means to modify personal information so that an individual cannot be directly identified from it. though a risk of re-identification remains. As such, de-identified data will remain under the scope of the new law. However, the CPPA does go on to clarify the distinction between de-identification and anonymization. Anonymization for the purposes of CPPA means to irreversibly and permanently modify personal information. This would generally be in accordance with best practices set by organizations such as ISO or NIST, to ensure that no individual can be identified from that information, whether directly or indirectly. If an organization seeks to use anonymized data, they must establish methods of anonymization and measures to manage the use of such data. Ensuring so would render this data outside the scope of CPPA. This also means anonymized data would fall outside the scope of any retention thresholds, unless it is covered by any other law, of course, that any organization may be subject to, such as the Income Tax Act. However, when it comes to fulfilling business purposes for which personal information is collected, the CPPA specifies that an organization must not retain the information for a period longer than necessary to achieve that, or comply with any other applicable laws or reasonable contract terms. The personal information must be disposed of as soon as feasible after such period. It is important to note that the sensitivity of the personal information should always be a consideration for this exercise. Conversely, if any individual makes an access request to the personal information held by the organization, that information must be retained for as long as necessary to enable the individual to exhaust any recourse that CPPA allows. In any case, under the principle of openness and transparency, the CPPA requires organizations to communicate applicable retention periods for such sensitive personal information in plain language, of course. On the principle of individual access, a notable addition in the CPPA is the right to data mobility, once again, subject to certain stipulations. Under the new law, individuals would have the right to request an organization to disclose their personal information to another organization of their choosing. Upon receiving such a request, the organization in possession of the information must transfer it over to the designated organization as soon as feasible, provided both organizations are subject to a data mobility framework. Which organizations would be subjected to that framework has yet to be determined. This would have to be revealed via additional regulations, which are also expected to prescribe safeguards that must be put in place by organizations and parameters for the technical means that can ensure interoperability of such disclosure and collection. Another data subject right incorporated in the CPPA is the right to an explanation regarding predictions, decisions, or recommendations put forward by automated decision systems. If an organization utilizes such technology that could have a significant impact on individuals, it must, on request by that individual, provide them with an explanation indicating the type of personal information used to make the prediction, recommendation, or decision, the source of the information, and the reasons or principal factors that led to the outcome. An imposition on the individuals put on by the new legislation is that such a request must be made in writing. The organization, however, must assist individuals who require assistance in preparing a request, indicating that they have a duty to implement internal procedures to facilitate this right. This includes availing a general account of the organization's use of automated decision systems that could have a significant impact on individuals. For clarity, CPPA goes on to describe what constitutes an automated decision system. That is, any technology assisting or replacing the judgment of human decision makers through the use of a rule-based system, regression analysis, predictive analytics, machine learning, deep learning, a neural network, or any other technique. Continuing with the rights of individuals, though, a significant addition in the CPPA is the right to disposal. In other jurisdictions, this may be referred to as a right to be forgotten or right to erasure. wherein organizations are required to have a mechanism for the removal of personal information of individuals from their systems upon request. However, if an organization disposes of personal information at an individual's request, it must also inform any service providers who have had the information transferred to them and ensure that they dispose of the information as well. This emphasizes that whether an organization collects information directly from individuals or work with data processing within a supply chain, they need to understand record keeping and employee access procedures. They also need to understand where their data is stored, including redundancies, in order to ensure total removal of personal information relating to an individual. Doing so gives them more control over their data. Now that we have discussed the current state of law and proposed changes around it, let's take a moment to consider how it may impact organizations in terms of enforcement should the CPPA come into force. As expected, the OPC would be responsible to oversee compliance. However, the CPPA introduces a new authority that would be responsible for imposing fines and penalties. That is the Personal Information and Data Protection Tribunal. The commissioner would have the ability to make recommendations to the tribunal regarding amount to be sanctioned on an organization for non-compliance, but the tribunal would not be bound by it. A decision of the tribunal is final and binding, and except judicial review is not subject to appeal or to review by any court. It would be treated in the same manner as an order of the court. The OPC, however, would have expanded powers to conduct inquiries, audits, issue compliance orders, enter into compliance agreements, certify codes of practice, and initiate complaints to trigger investigations. It is important to note that where the commissioner or tribunal identifies a finding following an investigation, it triggers a private right of action for individuals impacted by that finding. This can leave organizations vulnerable to class action litigation. In terms of fines and penalties, organizations who knowingly contravenes requirements pertaining to record keeping and notification of breaches or retention of personal information to enable individual recourse, respecting compliance agreements, retaliation towards good faith whistleblowers, or obstruction of commissioners' powers would be guilty of an indictable offense and liable to a fine of up to 5% of gross global revenue or $25 million Canadian, whichever is greater. The maximum penalty for all other contraventions in a recommendation could be up to $10 million Canadian or 3% of the organization's gross global revenue, whichever is higher. Having said that, the most intriguing question that surfaces is, what can an organization do to be adaptive towards any curveballs that regulators may throw at it? That is what Sujoy will delve into in our next section. Over to you, Sujoy.
Thanks, Safayat. So both PIPEDA and the CPPA emphasize data protection. The most important step for an organization to take is to account for the personal information it collects and to fulfill business purposes for those uses. So a tool that's commonly used for this is a data inventory. And under the GDPR, the European Union legislation, it's typically called a record of processing activity, or ROPA. So data inventories involve the development and maintenance of an inventory of personal information and how you process that data. It includes information classification, whether you have identifiers, demographic information, health information, or financial data. It also encompasses the sensitivity of the data, whether the data is publicly available, confidential, sensitive, or highly sensitive. And it also tells you information about the types of individuals that the personal information is collected from. So are you collecting information from customers, employees, vendors? That is supposed to be captured within a ROPA. The owners or controllers and the processors of the data, including third parties and business partners, are also recorded within the ROPA. as well as how the information is stored, the IT systems involved, and what your retention limitations are. So on this next slide, we're looking at the development of the data inventory and how that is a fundamental task for a privacy officer. Organizations are best advised to have a dedicated resource for this. Depending on the size and amount of personal information you manage, that may be a single individual or it can be a shared responsibility. So in smaller organizations, the privacy role can be shared among one or more members of the leadership team. This can either be the CEO or typically your general counsel. These are roles that serve as privacy officers as well when you don't have the personnel or staffing numbers to have a dedicated position. But regardless of how an organization is structured, the designation of this accountability is key, and it should be documented in a charter that provisions for a privacy management program. In addition to developing a privacy management framework and strategy, the privacy officer should align with business objectives and assign privacy-related roles with any responsibilities among any line of business. So this could typically include your IT department, cybersecurity, legal, procurement, HR, marketing, basically any department that has the potential to manage or process personal information. It's important to understand who is responsible, accountable, consulted with, and informed of these processes. When we're talking about operationalizing risk management, it's important to have this taken from the policy that you have. So your privacy policy basically contains the instructions for how to operationalize your best practices. So your cybersecurity risk assessment guidelines would include information on the organization's risk tolerance for privacy and cybersecurity risks, risk management roles and responsibilities, thresholds for assessments, which consider the likelihood, impact, and sensitivity of the information that you have, or the likelihood and impact of a breach occurring, what methods you have for the processing of privacy, and what risk identification process you have in relation to cybersecurity matters. You'll also have to document the treatment of those risks, what mitigation is in place, and acceptance of those risks. The documentation also calls for accountability, so who to communicate with when an incident occurs, and how to report information that would be relevant to stakeholders. So there's an obligation on risk owners to maintain a risk register and also develop a framework for ethical analysis of any sort of information used from an analytic standpoint. A key tool important for many organizations is to have a privacy impact assessment process, a policy that focuses on PIAs, short form for privacy impact assessments, helps tell the regulator that this organization does their due diligence. So within that PIA policy, which is one of the requirements under this new legislation, the best practice is to indicate the purpose of the PIA, so when and why they are required, what kinds of information is included in the PIA, documenting the roles and responsibilities for performance and review of PIAs, and also monitoring the execution of risk mitigation. There is also identification of privacy risks and a threshold analysis to determine if a PIA is even necessary. So if you have systems in place that don't really manage a lot of personal information, what kind of analysis do you do to decide whether a PIA is necessary? Finding that out helps you save a lot of time, and it helps you determine what is actually a priority and what would meet the threshold for being captured by the Act. So it's a leading practice generally to conduct PIAs for high-risk data processing activities, or when an organization undergoes changes that relate to people, processes, and technology. In addition to a PIA program, a vendor management program also helps mitigate the organizational risk that you face from a personal data standpoint. Organizations should integrate cybersecurity and privacy when evaluating third parties. Programs should consider evaluating third-party cybersecurity and privacy postures during negotiations and onboarding, conducting data transfer risk assessments to understand data sharing and transfer risks, and to identify risk mitigation plans and controls. The program also contains information on how data is segregated, sharing requirements, and what happens in the instances where personal data is shared. You should be periodically reviewing and auditing your cybersecurity and privacy contractual terms and update as necessary in collaboration with your legal counsel. Maintaining an inventory of third parties entrusted with personal information is an important data cleansing practice. It helps you understand what kind of information you're holding, who has access to your information, and it helps you map out how those relationships can change as you have differences occurring over time in terms of your vendor management. So we're going to shift a little bit here and talk about a different aspect of privacy programs, and that is what are the rights of the individuals as it relates or as it's explained within the Consumer Privacy Protection Act. So organizations should be developing guidelines pertaining to the intake of how they interact with individuals, whether that's complaints or managing data subject access requests. You should have a procedure in place that allows you to identify who your customers are or who your stakeholders are. You should be able to authenticate those individuals. So are you talking to who you're actually talking to? You should be able to classify, triage matters based on the validity of those requests. So is a request reasonable? That's one of the considerations. What are your processes for locating, retrieving, and deleting information? And under what circumstances would you refuse access in accordance with the legislation? Where would you be allowed to do that? That's an important aspect to think about. Lastly, are you responding to requests in a timely manner within the set timeline based on the legislation? And how do you resolve complaints that are escalated beyond a standard request? So organizations should be able to define and implement a comprehensive retention and deletion schedule as well. This complements your data inventory, which was mentioned previously. Additionally, when you have agreements with third parties, when those are terminated or expired, what happens to that data, that personal data held by that third party? Do you understand how that data is removed from their systems? And what kind of documentation do you receive? So are there receipts which confirm deletion of personal data? Important to maintain those records as well. We're looking to the next slide here, and we're also looking at the regime that exists for penalties and the sorts of dollar figures, amounts that are associated with penalties under the CPPA. So one of the grounds for higher penalties within the Act is if your organization has inadequate protection of personal information. So what does that mean? Having inadequate protection means that there could have been practices in place or industry standards that are not being applied, something that would have mitigated risk in relation to access management, or having policies that govern how access is managed, having that communicated to your employees and staff. Those are all important factors to have. And so this access management policy should contain the following 5 components. And there are 5 broad categories, but broadly speaking, your policy for access management should speak to what's the purpose of access, what kind of applications are within scope, the environments and types of access covered by the policy, whether that is standard accounts, vendor accounts, third-party access, basically what's the role-based access that's allowed and that's documented within the policy. Second point is that you should have authorization and authentication models in place, including password utilization, multi-factor authentication, and VPN requirements. Are those needed? To what extent? And the design of those processes. So you need a process for managing those accesses. So that includes access provisioning, what enables modifications, terminations of access, and under what circumstances would access be reviewed. Last point is to speak about policy compliance. So who owns this policy? You have to have that accountability within your organization. What are the reporting requirements and structure that exists to support the policy, and who's held accountable? So depending on the size of your organization and the sensitivity of the personal information managed by your organization, you should also have a vulnerability and patch management policy, which helps with data loss prevention. Consider those mechanisms as you're taking a look at this legislation and requirements. So these concepts are all closely linked to the safeguards that exist for incident management. There is a ground for higher penalties under the CPPA, and it involves notifying the commissioner and other individuals of a privacy breach. Failure to provide notice of a breach in a timely manner may result in an indictable offense. And as a result, organizations should develop an incident response plan that defines the procedures to perform when a privacy breach is detected. So your privacy breach plan should articulate the procedure to follow from incident detection through resolution and post-incident review, the roles and responsibilities you have for your employees and any third parties who may be involved in handling incident identification, triaging, investigation, documentation, and communication, as well as how you resolve the breach and what kind of remediation measures you have in place. It's important to have reasonable resolution timelines, and you should have some process for your employees, individuals to report incidents and breaches. A lot of this relates to how your organization personnel are informed. So as we look at this next slide, we're looking at privacy training being an essential and ongoing component of your privacy management program. So privacy management obviously is very, it's throughout the legislation, something that is important and re-emphasized. So it looks at policies, procedures, and solutions, and basically what would make that effective. And one way to ensure that effectiveness is to have appropriate training in place. A privacy management program should have that awareness, and it should be part of the onboarding process for new hires. You should also look at the schedule with which that training is provided. So is it provided on an annual basis? Is it quarterly? Typical advice or a good practice is to have semi-annual privacy training, but it really depends on the volume of personal information, the extent to which you have new employees coming in, the turnover associated with that. And managing that is a large part of having a robust, sustainable privacy management program. So some factors to consider for training would be aspects of training that should be included in your program. So do you enable your employees to recognize social engineering attacks? Do they understand what a phishing scam is? Are there issues around tailgating or pretexting? Are they aware of those terms? How can you educate them? It's important to inform employees of best practices around authentication, multi-factor authentication, what makes a good password, what makes a strong password, and then how do you manage those credentials over time. So training material should be reviewed and updated annually or when significant enterprise changes occur. And these are ones that would typically impact your privacy practices. Recognizing these practices helps you maintain an informed and up-to-date workforce that can manage privacy in a way that's complying with legislation, allowing your organization to stay ahead of any potential breach. And if a breach does occur, you're able to manage it with a proper workforce that's informed and aware of best practices. So I'll close off my section before transitioning to Safayat's portion to just say that in this slide, we're talking about the existing frameworks that are around that will help you measure the performance of your privacy program. So it's not really something that's new, something that organizations have been doing since PIPEDA. So you have ISO standards, you have NIST and COBIT as frameworks that can be helpful. And generally, these are agnostic when it comes to regulation. So it's good to know that these tools exist and they're updated a pretty regular basis so that you can rely on those to have compliance with global privacy laws. And that's becoming more and more relevant as the nature of these laws converge, because what we're seeing with this new bill proposed in Canada is a convergence with GDPR. And one aspect of it that should be highlighted and is part of the next slide, and where Safayat will take over, is a discussion of artificial intelligence and this new aspect of Bill C-27, which is different from the previous version. So I'll pass it back to Safayat to continue the discussion there.
Thanks again, Sujoy. Part 3 of Bill C-27 proposes the Artificial Intelligence and Data Act, ADA. We can also refer to it as, which introduces new rules aimed at mitigating risks of harms and biased outputs from AI systems. AI systems autonomously or partly autonomously processes data related to human activities through the use of an algorithm, neural network, machine learning, or another technique in order to generate content or make decisions, recommendations, or predictions. ADA requires organizations to monitor compliance and record keeping on measures and assessments of high-impact AI systems. This means that organizations must maintain plain language and publicly available descriptions of how high-impact AI systems operate, identify the type of content generated from the AI system, indicate the type of decisions, recommendations, or predictions the system is intended to make, have measures in place to mitigate serious harm to individuals or biased outputs. In addition, the owner of an AI system must maintain a record about the manner of anonymizing data and its use or management, mitigating risks of harm or biased output and monitoring mitigation activities, and conduct assessments of whether the AI system is a high-impact system. The definition of a high-impact system remains unclear, though this might be prescribed by legislation and a governor in council. The ADA is a first for AI legislation and has implications for businesses that design, develop, operate, license, or sell AI systems. The ADA is a first for AI legislation and has implications for businesses that design, develop, operate, license, or sell AI systems. This is Canada's response to AI as a rapidly growing industry. Comparisons can be readily made with the European Union's AI Act. Both pieces of legislation follow a harm-based approach, with ADA focusing on mitigating the harms and biased outputs. Organizations may be fined for contravening the requirements of ADA, which are properly anonymizing data, assessing whether an artificial intelligence system is high impact, measuring and mitigating the risks of harm or bias, monitoring mitigation measures, keeping general records, and publishing a plain language description of how the AI system is to be used and managed, including how the system is intended to be used, the types of content that it is intended to generate, and the decisions, recommendations, or predictions that it is intended to make, mitigation of risk, and any other information as prescribed by regulation. Lastly, organizations responsible for high-impact systems must notify the minister as soon as possible of any material harm that has occurred or may arise from use of the system. With that, I will pass it back to you, Sujoy.
Thanks, Safayat. So that concludes our presentation. We hope that this has been informative. We would just like to mention at this point that the legislation is very new at this point. It's a continuation of laws that were introduced under Bill C-11 at the end of 2020. We're seeing a lot of changes happening in this field, and there's going to be a lot of opportunities for organizations to understand what the implications are for personal data. We are seeing this convergence, And in that sense, it is a positive step towards greater conformity, regardless of your territorial jurisdiction. But seeing the similarity in these laws and also seeing these newer, more responsive pieces that address technology, that look at artificial intelligence, are really a good indication of what legislators are thinking is going to be important. And we're actually learning how they're going to be speaking about this. So thank you again for listening. We're happy to be part of this and welcomed into your community. And if you require any further information, please feel free to connect with us on LinkedIn. Thank you again for your time.